Hi, this is Curt, and welcome to another edition of Fire Law Roundup. Case out of Montgomery, Alabama, and we had a fire chief who, back in 2018, he was a chief of ops, and as I understand it, he was the number 2 in the department, or at least he was a direct report to the fire chief. So he's a high-ranking officer, and he apparently had some sort of a altercation with an ex-girlfriend. There was a number of issues. He went over to her house with a fire department vehicle off duty after he had attended some sort of a conference, and bottom line is he ended up with there ended up being an arrest warrant out for him. So and it was from the Montgomery Police Department. So apparently there was some consultation between the police department and the fire department, and the morning that apparently he became aware of the arrest warrant, he had a conversation with the chief. Interestingly, there was a difference of opinion of exactly, or a difference of recollection of exactly what was said between the two of them, with him saying that the chief told him in order to preserve his pension, he needed to resign. The chief's recollection was that they didn't discuss that at all, only that, he had to address this thing, and it needed to be addressed appropriately, and that he was going to be suspended without pay, or suspended with pay, I guess. So at any rate, the chief ended up resigning, and he was apparently, because of the way that he resigned, he was not eligible for certain buybacks, apparently, of his accrued sick leave or what have you, because in order to be eligible for that, you have to give at least 7 days notice, and he resigned immediately. So I'm not sure what other benefits he may have been denied. The opinion wasn't really clear on that, but bottom line is he filed a lawsuit claiming that he was put under duress, that he was misled by the chief in terms of what his options were, and that the chief should have realized that he was under a lot of stress, and he didn't fully understand what he was doing, or the typical what we call Brad, help me out here. I'm
duress. Well, you're right. You can say a contract is invalid because it was based on coercion or duress.
I got it right here. Constructive discharge. Okay,
okay.
It's actually 2 terms: constructive discharge and constructive termination, but they essentially mean the same thing. That yes, I resigned, but it was not a voluntary and knowing resignation. Therefore, I should get my job back. So that was the basis of his claim, and the court didn't really buy it. And I don't want to get into the details of their credibility determination, but the court made a very well-reasoned credibility determination. The reason I want to talk about that is that's something that we don't really talk about in a lot of classes for firefighters. Certainly attorneys talk about credibility determinations, but when it comes to decisions on disciplinary matters, and you have the classic he said, she said, how does the fire department determine who to believe and who not to believe? Okay, firefighter A says something happened, firefighter B denies it. How do we determine who we're going to believe? That's a credibility determination, and the court did a good job. So anybody who's interested in that, you can take a look at the decision. The court basically sided with the fire chief, and they said that some of the chief of operations statements, that his testimony doesn't really make sense. The court said it was kind of unbelievable that someone in that position, where just below the fire chief, wouldn't be aware of what the consequences are of a resignation relative to his or her pension and so on. So Interesting way. I've got a class coming up on that issue on credibility determinations, and it's an area that interests me. It's a fascinating area. It's kind of separate from spotting lies. Like and in the class we'll show a couple of videos of people stating things, and one of them President Clinton, but we'll show a video and stop the video and say, do you believe them? And why? What causes you to believe him? What causes you not to believe him? And is that enough for a court to make a decision? And in the context of discipline, you can't just say, I believe firefighter A because I believe firefighter A. You have to say, why do you believe firefighter A? Why is firefighter A more credible than firefighter B? The court does a pretty good job of explaining some of the criteria. And again, the class, we get into it in a lot more detail, but it's a fascinating area to me. But at the end of the day, the chief who was seeking to get his job back or obtain damages lost the case. And we'll see if there's going to be an appeal. But that was the Alabama case.
And it is very difficult, having just appeared in appellate court. I try to teach people facts. The factual record is made at trial. When you are on an appeal, you are not arguing the facts, because the deference is almost always given to the judge or jury on the facts. You have to identify an error of law. But if you're trying just to say, well, the trier of fact, the judge or the jury was wrong, they had the wrong opinion, you pretty much always lose. It's a very tough thing to do. My takeaway from this case really is, to everybody as a professional, right? When somebody is forcing you to resign or forcing you to admit something, and look, Weingarten gives certain people protections, and right, but here, I would be writing a letter. Yes, right after I resigned and you didn't take away my benefits, or I resigned and you didn't tell me this, or I resigned because you gave me 2 seconds notice. I will tell everybody that what I have seen is incredible. When you send a letter almost immediately saying this is what happens, and they don't respond to refute it, it is believed to be very credible. Even though you're just writing a letter, it's not a recording or anything. When you send a letter, documenting what happened, it's very credible. And this is not just a lesson for, hey, I'm being forced to resign. This is a lesson for any meeting you have of any significance, right? If there aren't minutes taken, and it affects you or your department or a decision or something you're uncomfortable with, write them. Because if you think you're going to remember, or the facts are going to be remembered, or you're going to leave it up to a judge to determine who's telling the truth, you're giving up a big chance to protect yourself if you would just send a letter reciting what happened.
Yeah, interesting. That's good. I never really heard of that. I have heard of people sending themselves emails to document when, and I'm not, because especially firefighters and government employees, when you do that, even if you send yourself an email, that is not confidential. It could be a public record. Certainly it's going to be archived somewhere. You want to be very careful about that. But I like that idea of basically summarizing what your version of what happened was. And if the person doesn't respond back and refute it,
it looks bad for them.
Well, certainly would be a factor in a credibility determination. Absolutely.
Yeah, because why would I lie? I just put it in writing to you. Why would I lie? But
sure, one of the most important things with the credibility determination is corroboration.
Right.
And that would corroborate. That would be corroboratory documentation of your version of what happened. So, and I do want to mention, we will be, we have a recording of your appearance before the court. Was it the Court of Appeals? Or was
it's the second level is the appellate division. The
appellate division. So we have a video of that. Malcolm will be working on it, and we're going to post it here for all of you to see. I thought you did a terrific job. It didn't seem like the court fully grasped the issues, which is not surprising. I mean, I wish we could argue our cases in front of a panel of firefighter attorneys instead of judges who really don't grasp some of the key nuances of our situation. But
yeah, and I will say this to everybody, because I tell clients, right or wrong isn't necessarily the issue. It's not the issue going in, and right or wrong may not be the issue coming out, because the second department of the appellate division, which for those familiar with New York State, has Nassau County, Suffolk County, most of the boroughs. It's an extremely overworked court. So they have a law clerk who prepares a brief, a law clerk with way less experience probably than, most of us, but a law clerk reads things, gives them a set of alleged facts and questions to ask.
That's scary.
Judges don't have time to look at it. So as people will see, and maybe we'll talk about it, not so much for the purpose of, hey, here's Brad arguing, but so people understand, court isn't always about truth or not truth. Sometimes it's about the fact that you only have a couple of seconds to make an argument. The argument I made was on page 2 of my brief. It was the second major argument. And as you've lectured on a million times, you can't prejudge guilt. You can't impose a sentence. And there's no question what happened. But these judges, I focused my whole argument on one letter. And these judges like, oh, I've never seen that letter. They had no idea what I was talking about, which amazes me, right? Blows your mind that people have no idea what you're talking about when it's your main argument. And that's because some clerk who briefs the judges didn't think it was important enough to brief them on. So that, unfortunately, is the reality of the justice system. It is not always just. Sometimes can I just throw a case out because we don't have time for it?